Hello everyone, I hope you're staying nice and warm. I apologize for not getting this posted technically on Friday. As you know, we had a snow day today, which means daycare was closed, which means I needed to wait until my roommates were asleep before making this recording. As a reminder, the purpose of this recording is to do a number of things. Number one, let's go back to strict liability. Let's review what we were discussing in class and clarify any questions or concerns we may have had about what a strict liability crime is and how we determine whether or not an offense or an element within an offense is strict liability. From there, we're going to continue our discussion with mistake of fact. As you know, during our last class, we were able to discuss mistake of fact as it applies under common law. With this recording, we'll continue that discussion with the application of mistake of fact under the MPC. From there, we'll move on to Actus Reus, or the guilty act. In particular, we'll be discussing the voluntary act, and we'll talk about omissions, when a failure to act along with a legal duty creates criminal liability. Again, last class, we finalized our discussion on mens rea, and in particular, we're looking at strict liability crimes. For those of you who are still confused as to what constitutes a strict liability crime, here are some general guidelines. Again, the general rule is that most crimes have a mens rea. So if you're looking at a statute and it lacks a mens rea, do not assume that it is a strict liability offense. These are rare and they're really limited to certain crimes and certain contexts. In particular, what we're looking for is a public welfare offense. So generally, these are crimes that are focused on health, safety, and environmental regulations. Think about food regulations or the selling of prescription drugs or even pollution violations. They also may include your typical traffic violation, so speeding, parking, driving with a suspended license, etc. Again, these are crimes that lack a mens rea. So long as you've done the act, you are criminally liable. It may also include the sale of alcohol or tobacco to minors. So we had a hypothetical come up in class. Again, selling alcohol to a minor, it is considered a public welfare offense. Remember, though, there are some strict liability offenses that aren't so focused on public welfare, and those in particular are common law sex crimes. So we see this with statutory rape, bigamy, and adultery. So again, they don't look like a typical public welfare offense, but they are still a strict liability offense. When determining whether or not something is strict liability, again, look at the penalty. It should be a fine or have limited jail time. That said, there is the exception that exists for those common law sex crimes. If you are convicted of, for instance, statutory rape, you are looking at a significant penalty. You'll also want to be considering the stigma that will attach. And what this means is that if you are convicted of a strict liability offense, it's usually either a misdemeanor or infraction. Anytime you're seeing an offense that's a felony offense, it's probably not strict liability. Again, though, there is the exception for the common law sex crimes. If you are convicted of, let's say, statutory rape, you are looking at a felony. So there are really two situations in which you're going to have to determine whether or not an offense is a strict liability offense or whether an element contained within the offense is strict liability. So the first situation is a situation where there's no mens rea in the statute. If you come to a situation like this, first of all, don't presume it's strict liability. Second, the general practice is to apply purposefully, knowingly, or recklessly to all material elements of the statute. During class, I had said non-material. I had flipped the two. It should be non-mental material elements. But for the sake of simplicity, all you need to know is that the general rule is when there's no mens rea, we're going to apply purposefully, knowingly, or recklessly to all the material elements. The second option is if you are able to determine, using those factors we just discussed, that the statute is strict liability, then there is going to be no mens rea in the statute. Again, this is rare. It's not the general rule. Now, if you're looking at a statute and there is a mens rea, but it's unclear if the mens rea applies to all the material elements, you have a couple of different approaches. The first of which, and the most common response, is to carry over that existing mens rea and apply it to all of the material elements that are contained within the statute. And again, this is the carryover rule. This is the approach taken by the Model Penal Code, and for the most part, it applies under common law. The second is when looking at the statute, you may determine that the material element is a strict liability element, and thus the mens rea does not carry over. Now, before we continue with our discussion, let's break down some vocabulary. In particular, let's talk about the different kinds of elements. So, if you hear me or you read in the book talk about a non-mental element, all that is an element that's not the mens rea. So that would include your actus reus or any attendant circumstances. When you hear the word non-material element, what it's referring to are specifically the statute of limitations, jurisdiction, venue, the specific punishment or level of offense like felony. It would also be any element that's unrelated to the harm or the criminal conduct. And finally, with regard to material elements, that's all the other elements. So really, non-mental, everything but mens rea. And the other large distinction is material versus non-material. Non-material are those statute of limitations, jurisdiction, venue, punishment, anything not connected to the harm or conduct. And material is everything else. Now, continuing our background discussion, when you are looking at a common law statute and you have a mens rea and you're trying to determine whether or not that mens rea carries over and applies to the other material elements, again, you're always going to look at the text and see if the text gives you any indication. You'll also look at the legislative history. Usually the legislative history isn't very helpful, but again, consider it. And then finally, you'll look at those bash factors. Again, I've highlighted in yellow some of the more important ones, and I hope you notice that some or many of the factors here are those same factors that we discussed in that previous slide. So let's talk in particular about when doing a common law statutory analysis, what is a textual analysis? What does that look like? Okay, so the issue is, again, we're looking at a common law statute. You have a mens rea in the statute, and you're trying to determine if the mens rea is going to carry over to the other material elements in the statute. So in doing this textual analysis, the first thing you're going to consider is the placement of the mens rea within the statute. Okay, so the typical rule is that the court is going to presume that the mens rea applies to each material element that follows it. So what that means is if we have a statute that says, whoever in any manner within the jurisdiction of a federal agency knowingly makes a false statement is guilty of an offense. If we identify the mens rea, it is knowingly. And what the placement of the mens rea tells us is that knowingly is going to apply to all of the material elements that come after it, meaning knowingly is going to apply to the makes any false statement aspect of this offense. It's not going to apply to anything that comes before it, such as in any manner within the jurisdiction of a federal agency. Next, moving on to punctuation, the general rule is that if you're looking at a statute and you have a section of the statute that's separated by commas, the idea is that the mens rea doesn't apply to that portion of the statute that is in between the commas. So, if we're looking at a statute that says any person who knowingly confines another without authority of the law in a state prison is guilty of false imprisonment. Again, we are dealing with a statute that has a mens rea, that's knowingly. But in this particular statute, you'll note that there is a section that is sectioned off with commas, without authority of the law. What this particular textual statutory analysis tells us is that knowingly would apply to the elements of confines another and in a state prison, but it's not going to apply to that section of the statute that's within the commas, meaning knowingly doesn't apply to without authority of law. Again, it's sectioned off or separated by those commas. And finally, when learning or determining whether or not the mens rea applies to a different portion of the statute, look at if it has certain subsections. The general rule is that a mens rea in one subsection doesn't necessarily apply or carry over to a different subsection. That said, if the mens rea is present in the parent provision, so it's in, for instance, section 1, and then we have subsection A and B, then we're going to presume that the mens rea that's in section 1 carries over to A and B, because again, it's the parent provision of the subsections. So, for example, if subsection A contains a mens rea of knowingly, but subsection B doesn't have a mens rea, don't assume that knowingly from subsection A carries over to subsection B. That said, if you have a parent provision, so we're dealing with section 1, and that has a mens rea, then you can assume that that knowingly mens rea from the parent provision will carry over to the subsections A and B. Okay, how does this work under the MPC? The MPC, you will be pleased to know, is much simpler. So again, we're dealing with a statute that has a mens rea, and we're trying to determine if that mens rea applies to all the material elements. What we're going to do is, under the MPC, if the statute has the mens rea, it is going to carry over and apply to every material element unless a contrary legislative intent plainly appears. Again, this is our carryover rule. An example of this would be false imprisonment. If false imprisonment is knowingly restraining another so as to interfere substantially with his liberty, we, number one, know we have a mens rea, knowingly. And what we're going to do with that is we're going to apply it to every material element. In this case, if we break it down into its element, we know restraining another is the actus reus, and so as to interfere substantially with his liberty is an attendant circumstances. Now, the actus reus is a material element, and as to interfere substantially with its liberty pertains to the conduct itself, so we know that is also a material element. Thus, knowingly applies to both the actus reus, the restraining another, and to that material attendant circumstance, as to interfere substantially with his liberty. All right, let's do an example. So first, let's look at the statute. This is the statute that was talked about in the case that we read in class. And in looking at the statute, we're going to ask ourselves, does this look like a strict liability offense or not? And in looking at it, it's aggravated identity theft. That isn't suggestive of a public welfare offense, nor is it one of those common law sex crimes. If you are convicted of a felony, so that's a serious punishment, and the penalty is significant in that it's up to 2 years. So again, we're dealing with a non-public welfare offense. We're dealing with something with a harsh penalty and significant stigma. So for those reasons, what we know is that this is not likely a strict liability offense. So now what we need to determine is we have a mens rea, we have knowingly. How does this mens rea apply to the material elements in the statute? So before we approach it under model penal code and common law, let's break down the statute. So again, we have a mens rea of knowingly. We have an actus reus of transfers, possesses, or uses without lawful authority. We have an attendant circumstance of a means of identification of another person. And we have a second attendant circumstance. This second attendant circumstance, though, it is non-material because it is specific to the penalty, right? You're going to be convicted of a felony and have an additional term of 2 years imprisonment. So under the model penal code and the carryover rule, what we know is that the knowingly is going to carry over to all of the material offenses, including the material elements, including that actus reus and that first attendant circumstance. So this means knowingly applies to both transfers, possesses, uses, etc., and a means of identification belonging to another. If we do this analysis under common law, we're going to have the same outcome. In looking at the statute and looking at the placement of the mens rea, it comes before all of the material elements. Thus, that suggests that the mens rea applies to all those subsequent material elements. Furthermore, we don't have any sections divided with commas, nor are we dealing with subsections. So again, same outcome. All right, let's do another example. So in looking at this statute, it is whoever knowingly uses, transfers, acquires, alters, or possesses coupons or authorization cards in any manner not authorized by the statute or regs. So first we have to ask, is this strict liability? This one's harder. It doesn't have information as to whether or not it's a felony. We don't know about the punishment. It's not even clear what this offense is. If this was a test, I would make it more clear. But in going through our factors, let's just identify number one, it's not a public welfare offense. It's not regulating food, drugs, alcohol, etc., nor is it concerning traffic. It's also not one of those common law sex crimes. So as a result, not strict liability. So next thing we have to ask is there a mens rea in the statute? And there is. It's knowingly. So now we need to determine if the knowingly carries over to the material elements. Before we talk about the model penal code and common law, let's break down the statute. So again, we have the mens rea, we also have an actus reus, and finally we have an attendant circumstance. And this attendant circumstance, it is a material element. So under the common law, what we know is the mens rea is going to carry over to all of the material elements, including the actus reus and that attendant circumstance. It's going to be the same outcome with regard to common law. Again, in looking at the statute, the mens rea is coming before the material elements, thus it will carry over. Furthermore, we're not dealing with a situation with commas separating part of the statute, nor is there subsections. Okay, let's look at the statute from the excitement video case. So first, is this strict liability? So in reading the statute, it is certain activities relating to material involvement of sexual exploitation of minors. So just in the title alone, it's clear that this is not one of those public welfare offenses. You may be tempted to say this is a common sex law crime, but again, remember, those are really limited to statutory rape, bigamy, and adultery. Furthermore, in considering the other factors, what we see is that it's not clear what the punishment is and what the if it's a felony or not. But I'm telling you, this would be a felony and the punishment would be significant. Again, if this was a test, I would give you that information. But we can conclude from this analysis, we're not dealing with a strict liability offense. So next we have to identify, is there a mens rea? And if there is, how does it apply to the material elements? So let's break down the statute. Number one, we have the mens rea of knowingly. We have an actus reus of transports or ships. And then we have several attendant circumstances. So let's look at those. So in the first subsection, we have a pretty long attendant circumstance. But if we read it, what it suggests to us is that this attendant circumstance is non-material. It's pertaining to the jurisdiction. If you transport something under foreign commerce, that's what's allowed the federal court to take the case. So again, that's non-material. And under subsection A, we also have an attendant circumstance. But in looking at it, this is a material attendant circumstance, right? It pertains to the conduct itself and whether the conduct involves the use of a minor. Okay, so under the model penal code, how would this work? Again, the model penal code says that the mens rea applies to every material element. Our material elements in this case are the actus reus, transports or ships, and subsection A, that the visual depiction involves the use of a minor. So what we know is that subsection A, that material element, it's not strict liability and knowingly is going to apply. Now let's do this analysis under common law. Common law becomes a little trickier because now we're in subsection category, all right? So starting with the beginning, the mens rea is coming before the attendant circumstances and the material elements such as the actus reus. Thus, we can assume it's going to carry over. But again, this is unique because it has subsections, so maybe that wouldn't be the case. So we have to look at where the mens rea is within the subsections. And in looking at this particular offense, the mens rea is in subsection 1, which is a parent provision to subsection A. As such, the knowingly will carry over to subsection A, which means the state is going to prove that not only was the defendant practically certain he was transporting or shipping, or actus reus, but also that the defendant was practically certain the visual depiction he was transporting involved a minor. Okay, moving on. Let's look at this statute. Is it strict liability or not? So, providing material support or resources to designated foreign terrorist organizations. Okay, not a public welfare offense, not about food, drugs, traffic, sex crimes, etc. In looking at this offense, it says that you are potentially looking up to 20 years incarceration. And it's not clear from the statute, but this would be a felony. So again, considering the factors, this isn't a strict liability statute. So now we have to determine, is there a mens rea? And if so, how does it apply? So before we discuss model penal code or common law, let's break down the statute. We do have a mens rea, it's knowingly. We have an actus reus, provides money. And we have a couple attendant circumstances. So our first attendant circumstance, this is a material element, okay? It's specific to the conduct. It's saying, did you give money to a charitable group that supports terrorists? Now we also have a second attendant circumstance, but this is non-material. It's only concerning the penalty. It's saying, if you're convicted, you're looking at 20 years to life. So how does this work under the model penal code? Again, the model penal code says that our mens rea is going to carry over to the material elements, meaning the mens rea is going to apply to the actus reus, provides money, and it's going to apply to that attendant circumstance, meaning the state will have to show you were practically certain you were sending money and you were practically certain that the money you were sending was going to a charity that supported terrorism. If we do this analysis under the common law, the outcome is going to be the same. Again, the mens rea is before the material elements, thus we can assume it's going to carry over. Furthermore, there's no sections that are separated by commas, nor are we dealing with subsections. So again, same outcome under common law. All right, let's do another. This is the statute from the Alonis case. Again, this isn't in your book, but this was the case I was talking about in class where the individual was posting his rap lyrics on Facebook. So our initial question, we can see that the statute doesn't contain a mens rea, thus we have to ask, is this strict liability or are we going to have to read in a mens rea? So in looking at the statute to determine if it's strict liability, we see number one, it involves interstate communications, specifically communications that contain a threat to kidnap or a threat to injure. So off the bat, this doesn't appear to be a public welfare offense, nor is it one of those common law sex crimes. Furthermore, in reading the statute, we see that you're looking at potentially 5 years, which is a significant penalty. All of this supports that this statute is not strict liability. So our next question is going to be, are we going to read in the mens rea, and if so, how does it apply? So let's break down the statute, first of all. Again, no mens rea, but we do have an actus reus, transmits. We have an attendant circumstance, the interstate or foreign commerce. Again, this is a non-material attendant circumstance. It's just pertaining to the jurisdiction. By posting your rap lyrics on Facebook, you're engaging in interstate commerce, which allows federal courts to take jurisdiction. We have a second attendant circumstance concerning the communication itself. Does it involve a threat to kidnap or injure? This is a material element, right? It concerns the conduct itself. And then finally, we have a third attendant circumstance, and this is specific to the penalty, which tells us it's non-material. So, knowing this, if we apply the model penal code, what we know is that we're going to read into the statute purpose, knowledge, and recklessness, and that those mens reas are going to apply to all material elements, meaning they're going to apply to transmit and they're going to apply to the communication involving a threat to kidnap or injure. Now remember, when doing this analysis, if you can satisfy purpose, you automatically have satisfied knowledge and recklessness. Furthermore, in the alternative, if you can't satisfy recklessness, then you can't satisfy purpose and knowledge. Either way, the big takeaway under the MPC is that this isn't strict liability, and you're going to read purpose, knowledge, and recklessness into the statute, and it's going to apply to the material elements of transmits, and that the communication contains a threat to kidnap or injure. Under the common law, it's the exact same analysis. We read in those exact same mens rea, and they apply to the material elements. Okay, let's look at this statute. So this statute, again, we don't have a mens rea, so we need to ask ourselves, is that intentional? Is this a strict liability crime? In reading the offense, what we see is whoever 25 years of age or older engages in sexual penetration with a person at least 12 but less than 16 years old is guilty of statutory rape. Ding, ding, ding. We know statutory rape is one of those common law sex crimes that is a strict liability offense. Thus, we know this is a strict liability offense and no mens rea is required. This is the same application under the Model Penal Code and common law. Okay, let's move on to mistake of fact and mistake of law. Again, mistake of fact, what you're saying is there's some sort of factual circumstance related to the mens rea that negates the mens rea. So an individual's mistake as to some circumstance shows that that individual didn't have the conscious object or purpose to commit the crime. Remember, this is a case-in-chief defense, and what that means is that what you're saying is that the state can't prove an element of the offense, like mens rea. They can't prove I acted purposefully, thus they haven't met their burden. Now, last class we talked about how mistake of fact applies under common law. Remember, you need to identify whether or not it's general or specific, and depending on the type of crime, the mistake must either be honest or honest and reasonable. So go and look at your notes from that class, and if you have more specific questions, put them on the discussion board. Now let's talk about how mistake of fact applies under the MPC. So what the MPC tells us is that, number one, we're not going to distinguish between specific and general intent crimes. The analysis under the MPC is as follows. Number one, every crime is treated as if it is specific intent. So we're going to look at the statute, and we're going to, using the statute, identify the mens rea. Next, we're going to decide whether or not the defendant's mistake did or did not the mens rea that's used in the statute. Okay, let's do an example. Take a second, pause the video, read the facts, read the statute, and decide whether or not she can argue mistake of fact under the MPC. Pause now. I hope you paused. Okay, let's break it down. So in looking at the statute, we have the mens rea of knowingly. Remember our first step, look at the statute, identify mens rea, knowingly. Okay. So what this means is under the MPC, if Maria can show that she was not practically certain she was taking the property of another person, then her mistake of fact could negate knowingly. And there are certain facts here that support that idea, right? In the facts, it says that Maria's roommate told her she could use the car. The roommate presumably told her where to find it. I would assume the roommate gave her the keys, or else she wouldn't have been able to start the car. So all of this would support that Maria was not practically certain she was using property that belonged to another. Again, remember, this is always a determination that's made by the fact finder, usually the jury. So the jury could decide not to believe her, but she could still argue mistake of fact to negate purpose, And if she does so successfully, the state will not be successful because they can't establish every element beyond a reasonable doubt. Okay, that's mistake of fact. Let's talk about mistake of law. So, mistake of law is similar, but you're saying not that I was confused about some circumstances, but rather that I was confused about some part of the law. I didn't know that what I was doing violated the law. In fact, I thought I was in compliance. Now, you should know the general rule is that ignorance of the law is no excuse. However, we do have two exceptions to this when you can argue that your mistake of law makes you not criminally liable. So again, when determining whether the exceptions apply, always go back to the general rule. Ignorance is no excuse, okay? More often than not, you're not going to be able to argue mistake of law. But in looking at the exceptions, let's look at the first, that you relied on an official interpretation of the law. So what does that mean? Number one, this is an affirmative defense, which means this is something that the defendant will argue in trial, and the defendant bears the burden of establishing all four elements. So what are these elements? Number one, the defendant must reasonably rely. Number two, on an official interpretation. And what this means is that this is not the defendant's own reading of the statute, nor is it an unofficial interpretation like they read ChatGPT or a blog. Number three, that the interpretation in fact is wrong. And number four, that it came from someone with the authority to interpret it, meaning the person who gave the defendant that information was either administering or enforcing the law. So we'll do some hypotheticals to put this into context. Okay, take a second, review this hypothetical, go through the four elements we just discussed, and determine whether or not Marcus can argue mistake of law. Pause now. Okay, I hope you paused and actually did it. Let's break it down. So again, remember, ignorance of the law is not a defense. So Marcus can't just go to court and be like, I didn't know I need a license. Like, that's not sufficient. So we have to determine whether or not he can argue mistake of law, specifically that he was relying on an official interpretation. So again, four elements, the first of which, did Marcus reasonably rely? So in looking at these facts, you could argue, yeah, he did, right? He went to City Hall, the appropriate place. He made inquiries before he set up his business. He received a clear answer, right? You don't need a license. There was no red flag suggesting this advice is unreliable. He reasonably relied. Okay, was this an official interpretation? Yes. It was not his own interpretation from ChatGPT or a blog he found online, nor was this a friend's advice or some random private attorney. The bar loves to test you on the random attorney, right? This advice came from a prosecutor who was acting in their official capacity. So this was, in fact, an official interpretation. Is the interpretation wrong? Number three, yep, needed the license. And number four, did the interpretation come from someone who had the authority to interpret it? So with this hypothetical, we're dealing with a criminal offense, right? You needed a license to operate your business. Because this is a criminal offense, the only person who is authorized to interpret it would be the person prosecuting it, so the prosecutor. In this case, that's what's happened. So because he can establish all four elements, this is one of those rare situations where Marcus could argue mistake of law, right? And as a result, not be found criminally liable. Looking at the second question again, remember Marcus bears that burden of proof. And yes, all four elements have to be satisfied in order to argue mistake of law, and he has satisfied them. Okay, let's do a plot twist. What if Marcus retained private counsel and his attorney gave him information instead of the prosecutor? Pause, think about it. All right. Let's break down the elements. Number one, did he reasonably rely? Again, assuming the other facts are similar, yeah, he did. Like he hired a private attorney. He asked before he created his business. There were no red flags. So you could say, yeah, he reasonably replied. Was it an official interpretation? No. This is not an official interpretation. This is a private legal opinion. Okay? Is the advice wrong? Yes. Remember, he's looking at criminal liability. And number 4, did that private attorney have authority to administer? And this is the biggest red flag. Remember, because we're dealing with a criminal offense, the only person that would have authority to interpret it would be the prosecutor, the one who is administering it. Here it's a private counsel. Again, the bar loves to test about this. You can't argue mistake of law when dealing with something in the criminal context and hire a private attorney to give you guidance. Okay, next plot twist. What if Marcus sees and approaches the prosecutor at a bar and asks his question, and the prosecutor, caught off guard, replies, "I think you're probably fine." Take a second, pause. Okay, let's go through the factors. Number 1, he may have relied on this, but did he reasonably rely on it? Arguably, no, right? A reasonable person, number 1, probably wouldn't have approached someone at a bar, right? And number 2, there are some red flags because this wasn't a clear answer. It wasn't like, no, you don't need a license. It was, I think you're probably fine. So the argument could be made that he didn't reasonably rely on it. Number 2, there is an issue as to whether or not this is an official interpretation, right? This doesn't seem like a very strong statement. It's tentative, it's non-committal. The facts say the prosecutor is caught off guard. So for these reasons, again, unlikely Marcus can argue mistake of law. All right, we've talked about the general rule, ignorance is no defense, the first exception. Let's look at the second. There is another instance in which you can argue mistake of law, and that pertains to situations in which one of the elements of the crime is that you had to know that your illegal conduct was violating the law. What this means is that the state must prove beyond a reasonable doubt that not only you violated the statute, but also that when you did so, you knew it was against the law. Knowledge thus becomes an element of the offense that the state has to prove. Now, you do not see this a lot. There are very few cases that involve this second exception, and usually when you see this, what you're looking at is a mens rea of willfully. So there'll be some statute that says not only did the defendant willfully do certain act, but they did so knowing it violated the law. Okay? Unlike the other exception, this is a case-in-chief defense. So with this, you're essentially saying, state, you haven't proven every element of the crime. You haven't proven that I, defendant, did the conduct knowing, again, it's a separate element, knowing that what I was doing was violating the law. Let's do a hypothetical. Okay, read through the facts and then pause. Let's break it down. So, Nina owns a small drone manufacturing company. A federal regulation lists certain drone components as restricted military technology, requiring an export license. Nina reads the regulation herself and incorrectly concludes that her drones do not qualify as military grade because they are marked for commercial photography. She exports 50 drones overseas without applying for a license. She is charged under the following statute. It is a felony to willfully export restricted military-grade drone technology and to willfully fail to obtain a required federal export license. Willfully is defined as the purposeful violation of a known legal duty. So again, looking at this statute, we're dealing with willfully. That should kind of cue you in. You might have a mistake of law argument. Let's break down this statute. Looking at it, we do have a mens rea, willfully. We also have 2 actus reus, exported and failed to obtain. And then finally, we have some attendant circumstances, restricted military-grade drone technology, and required federal export license. So, in looking at this statute, what is clear is that not only does the government have to show that Nina, her conscious object was to export the military-grade drone technology, but also it was her conscious object to violate the law when doing so, okay? So do you see how there are 2 elements that the state must prove? Not only did she do the act, but also that she did the act knowing it was illegal, okay? So what Nina is going to argue with the mistake of law argument is that the state can't prove beyond a reasonable doubt that she knew she had a legal duty and was intentionally violating that legal duty. If the jury believes that, then in fact she is going to be successful with the mistake of law because the state won't be able to establish that second element, that it was her conscious object to violate the law. The good thing is when dealing with mistake of law, the MPC is no different than common law. It's the exact same analysis. Okay, we're moving on now. Actus reus, and in particular, the voluntary act requirement. So this idea of the voluntary act is really emphasized in State v. Decina. So in this particular case, it took place in 1955. The defendant in this case, Decina, he suffered an epileptic attack while driving, and as a result, he jumped a curve and he struck 4 children, killing them. It's a really sad case. He was charged with and convicted of criminal negligence in the operation of a vehicle resulting in death. And before we look at the statute, it's important to discuss his medical history. So he was diagnosed with a particular form of epilepsy. In reviewing the doctor's testimony at trial, what was clear is that this is an individual who, for a long period of his life, suffered from seizures. So from 1950 to 1954, he had 10 to 20 seizures, none of which resulted in loss of consciousness. However, his most recent seizure was in 1954, so right around the time that this case came about, and it did involve the loss of consciousness. So again, he was So in looking at this particular case, Mr. Decina was charged with criminal negligence in the operation of a vehicle resulting in death. So let's break down the statute. We do have a mens rea, it's reckless or culpably negligent. We also have an actus reus, operates or drives any vehicle. And then finally, we have an attendant circumstance whereby a human being is killed. Remember, that's a harm, okay? So the issue in this case is whether or not Mr. Decina, at the time that he was operating the vehicle which hit the individuals, he did so in a voluntary way. Remember, an actus reus requires a voluntary act. Mr. Decina's attorney argued that he was not criminally liable because he lacked this voluntary act. The attorney was saying he wasn't acting voluntary, he was having a seizure, okay? So essentially, the attorney is saying the state can't prove its case. It can't establish actus reus because no voluntary act here occurred, okay? So what's interesting about this case is in the decision, the court makes clear any actions you do during a seizure, those are not voluntary. But what the court distinguishes is that the seizure itself wasn't a voluntary act. It was Mr. Decina's decision to drive knowing that he was subject to these seizures, okay? They said he knew he was an epileptic who had seizures. Thus, it was a substantial risk that he took to get behind the wheel and to drive. And that risk amounted to recklessness. Okay? Again, the voluntary act was not the seizure. The voluntary act was getting behind the wheel, knowing he might have a seizure. Now, you'll recall the dissent is not fond of this decision and says essentially, this exposes anyone with certain conditions to criminal liability anytime they get into a vehicle, okay? It also goes on to say that this potentially raises a rule of lenity issue, right? If you're always looking at criminal liability, if you have certain conditions, that's not necessarily fair to the defendant. That said, the court's ultimate holding, again, was that he is criminally liable. He did engage in a voluntary act. An important takeaway is that a criminal act includes a voluntary act. Not all acts need to be voluntary. So in this situation, his voluntary act was driving when he knew he could have a seizure. The seizure itself, not voluntary. Another important takeaway from this case is with regard to time framing, okay? So when we look at whether an act is voluntary or not, we have two approaches. The first approach is the narrow approach, okay? And that's going to look at the conduct at the time that the harm was caused. So for instance, if you are drag racing and you lose control of your vehicle and kill someone, in the narrow time framing, right, that moment you were drag racing and lost control, that was a voluntary act. Now, in contrast to the narrow approach is the broad approach. And so what that approach does is it says the voluntary conduct is the conduct that later posed a risk to an involuntary harm. So that's this case, right? The voluntary act was the knowing you had seizures and still deciding to drive, okay? It was the act that occurred before the involuntary harm. And then finally, another important takeaway here is the fact that certain consequences are unintentional does not make the act involuntary, okay? There's no doubt Mr. DeCina did not intend to harm those girls. That said, even though it was unintentional, that doesn't negate the voluntariness of his act. In understanding what constitutes a voluntary act, it's really helpful to look at the Model Penal Code. So again, when looking at the MPC, an Actus Reus includes a voluntary act. And what it tells us is a voluntary act is an act that is the product of effort or determination of the actor, okay? So a voluntary act is not a reflux, a convulsion, movement during sleep or unconsciousness, etc. So in Bay checking what a voluntary act is under the MPC, it's a willed bodily movement, right? It was your conscious determination to do something. It's not a reflux, movement during sleep or unconsciousness, conduct during hypnosis. The other thing that's important to remember is that the Model Penal Code does consider habitual acts to be voluntary. So typically, we might say some habitual acts are unconscious, but according to the MPC, it counts, right? So driving on autopilot, chain smoking, those are considered to be voluntary acts. Okay, let's do a hypothetical. Read through these facts and then pause and ask yourself, is the individual, in this case Dwight, was his driving a voluntary act? Pause. All right, let's break this down. So again, remember, a voluntary act is the product of one's effort or determination, okay? So in looking at these facts, what it tells us is that Dwight planned to get a ride home, right? But after hearing the police officer who told him, if you don't drive away, he's going to arrest you, after hearing that, Dwight got in the car and left, okay? Even though Dwight was responding to what the officer said, remember, his decision to drive off, it was still a willed act, right? He expended that effort to drive away. Thus, his act was voluntary. Now, you may not like this, and that's okay. Remember, just because you did a voluntary act doesn't necessarily mean you're criminally liable. This fact pattern is actually based off of a case, a New Jersey case. And in this particular case, the defendant tried to argue entrapment, that he wasn't given a choice because of the officer's demand. It wasn't successful in that case, but in other jurisdictions, defendants with similar fact patterns have argued entrapment and have thus not been found criminally liable, okay? So again, what we're really looking at here is, was it a voluntary act? It was, but just because it's a voluntary act doesn't mean you're criminally liable. You still have certain defenses you could raise, like entrapment, and remember, the state has to prove every element of the offense. Okay, let's do another one. Read through this hypothetical and ask yourself, was Jane's shooting of Charles a voluntary act? Pause. All right, so in looking at this is where time framing comes in, right? So we're asking whether her decision to take the gun and pull the trigger amounts to a voluntary act, okay? So in that particular moment where she has the gun and she pulls the trigger, right? That's a voluntary act. That is the broad framing, okay? She willfully and with determination, right, took the gun. Now, if we do a narrow approach here, you could potentially argue that it was not voluntary due to the recoil, right? She didn't actually do a voluntary act because the shooting of Charles was a result of the recoil, all right? So again, you could make the argument either way whether or not this is a voluntary act. If you're doing the broad time framing, it is, right? She willfully and with determination took the gun, pulled the trigger. If you do the narrow time framing, it's potentially not voluntary. It was only a result of the recoil that Charles was shot. All right, moving on. Actus Reus amounts to both a voluntary act or omissions, okay? Remember, when we talk about omissions, we're talking about a failure to act that comes along with a legal duty to act, okay? So with regard to legal duty, there are certain situations that give rise to this legal duty. Number one, special relationships. We often see this between spouses and parents and children. Number two, a contractual relationship, such as like a contract that a parent signs with the daycare, wherein the daycare agrees to take care and have a legal duty to protect the child. Same with like a lifeguard. Statutory duty. So this is like mandatory reporters, right? By statute, you have to report concerns about sexual or physical abuse. Also, Good Samaritan laws. Number four, if you create the danger. So if the person is needing assistance because of something you did, you may now have a legal duty to act. And number five, the voluntary assumption of care plus seclusion. So your book talks about a situation wherein two individuals come upon a shore and they see a child drowning, okay? And one of the individuals, John, is like, hey, other friend, you go get help. I'm the better swimmer, so I'm going to go rescue this child, okay? So friend runs off and John is swimming, right? But John decides halfway out, like he's tired and he's not going to do it anymore. And so he stops and the child dies. That would be an example of a voluntary assumption of the care, right? He told his friend, hey, I got it, you go get help. And then seclusion. His friend left, and then John doesn't follow through with rescuing the child. It's important to remember that any time you're trying to argue that the act has been satisfied by an omission, you must also be able to show that the individual was physically capable of acting and that they had the facts that would give rise to the need for action, okay? So these are requirements. In addition to a failure to act, you had to have a legal duty and you needed to be physically capable and knew that there was, in fact, a situation that gave cause for action. Now, here's a helpful saying to help you remember these legal duties, okay? Some cats save crying victims. Again, S, special relationship. C, contract. S, statutory duty. C, creation of the danger. And V, voluntary assumption of care plus seclusion. So now let's talk about omission and application through this particular case. So in this case, Terry, our defendant, she was charged with 2 counts of child abuse in violation of the statute. Essentially, the state alleged that she failed to prevent her husband from sexually and physically abusing her 2 children. In looking at the statute, here's the particular statute, the abuse of children. And so let's break it down. So with regard to mens rea, there isn't one, although the court says that she had to knowingly do so. But again, no mens rea. Actus reus, we have 2, tortures and subjects, and this is really what's at issue in the case. And then finally, with regard to the attendant circumstance, we have child. We also have the harm itself, right? The cruel maltreatment and what that looks like. So that is a material attendant circumstance. And then we also have is guilty of a Class E felony. That's talking about the punishment itself. So that is a non-material attendant circumstance. So the issue in this case is whether or not the defendant, Terry, she was required to act, or whether the statute was limited to the actors themselves who intentionally abuse individuals, okay? She argues that the statute was designed to only apply to the persons who directly abuse the children, and that she has no duty under this statute, thus she's not criminally liable, okay? The state, by contrast, argues that the mother in this case has a special relationship with the child, which creates a legal duty, and as a result of her failure to act, she is criminally liable. So the holding of this case is the court says that the defendant here is criminally liable. She had a legal duty and she failed to act. And the crux of the court's analysis really hinges on the definition of subjects. The court says, our statute doesn't define subjects, but the dictionary does, and it's a broad reading or interpretation of subjects. Not only does it include individuals who inflict physical harm, but it includes those who know about physical harm and fail to prevent it. In applying that broad understanding of subjects to this case, what the court determined is that the defendant in this case, she knew the father was abusing the children. That said, she continued to leave the father with the children, and she did nothing to prevent the abuse. She didn't call the authorities. She didn't utilize alternative childcare. Thus, she is liable. The takeaways from this case are it's an example of when an omission satisfies an actus reus, right? In this case, her omission or failure to act was to protect the children, and she had a legal duty. And this was a legal duty that arose due to her special relationship. She was a mother of these children. As a result, the actus reus is satisfied. It says mens rea, that's wrong. The actus reus is satisfied, and she is criminally liable for child abuse under the statute. This is an example of how a special relationship creates a legal duty. Now, in talking about the different legal duties, we did mention if there is a statutory requirement. So one of the main ways you see a statutory requirement is in the creation of Good Samaritan laws. Always remember the general rule is that there's no duty to rescue, okay? Unless a fact pattern is specifically telling you that a jurisdiction has a Good Samaritan law, you are to assume that there is no duty to rescue. That said, you may see one of 2 Good Samaritan laws that exist in a jurisdiction. The first of which is a statute that protects an individual from civil liability if they help or rescue others. It essentially says if you are a good Samaritan, right, you see someone who is suffering from a harm and you intervene and try and help them, that individual can't later sue you. Number two, there are other statutes, and this is the more traditional Good Samaritan law, that creates an affirmative duty to ordinary people, okay? So if you have the knowledge that someone needs help and you have the ability to assist, then there is an affirmative duty that you intervene and provide care, and failure to do so could result in criminal liability. So let's apply Actus Reus with regard to omissions to a few fact patterns. Okay, let's do a hypothetical. Read through these facts and then ask yourself, is Will criminally liable for Joanne's death? Pause. Okay, what do we learn from these facts? We learn a number of things. We learn, number one, that Will knows Joanne is going to die if he's not going to provide aid to her, okay? We know that Will could provide aid, right? He could clear out her mouth. He could flip her on her side. There are a number of things he could do. He could have a reason for not providing aid, right? Joanne is compromising his business, right? She's distracting his business partner and causing his business partner to relapse. Just because we know all of this does not mean Will is criminally liable. Remember, in order to satisfy the Actus Reus for an omission, you have to not only have this failure to act, but also a legal duty. So let's go through the legal duties and see if any of them apply. So number one, is there a statute? Nothing in these facts suggests that there is a Good Samaritan statute at issue or that could be applied. Number two, is there a special relationship? Nope. Nothing suggests that Will is Joanne's spouse or child. In fact, the facts suggest otherwise. What about a contractual duty? Nope, not here. What about voluntary assumption plus seclusion? There's nothing here to suggest that Will at any point tried to assist. And then finally, and this is where it becomes interesting, what about creation of the risk? I think you could potentially argue there's a legal duty as a result of Will creating the risk. That said, you would have to show that Will made the drugs Joanne used or provided them to her, okay? The big takeaway here is that omissions can only satisfy Actus Reus if there's a failure to act and a legal duty. Here, the failure to act is clear. The legal duty, though, is a little more complicated, and you might be able to argue creation of the risk, but again, you'd have to show that Will either made or provided the drugs to Joanne. All right, last hypothetical, and then we're done. Take a second, read through the facts, and then decide if Katie dies, could Julia be criminally liable for homicide? Pause. All right, let's go through it. So again, it's not only failure to act, but that you had a legal duty. Here, facts are clear. Julia did not act, right? She heard Katie fall. She opened the door. She sees Katie in the hallway, unable to move. It's suggested that maybe Katie is in the hallway for a while because she dies. Thus, again, Julia failed to act. But we have to also ask, did she have a legal duty to do so? Okay? Nothing in the facts suggests there's a statute, a Good Samaritan statute at play. So that doesn't apply. Status relationship. So some jurisdictions recognize roommates as a particular special relationship. So you might be able to make that argument. It's not as strong as a parent-child or a spouse's, but you might be able to make that argument. What about a contractual duty? Nope, none here. The fact that you're roommates and that you signed a lease together doesn't create a legal duty to assist in times of need. What about assumption of the care or voluntary assumption of the care and seclusion? Nope, nothing to suggest that applies here. And last, again, another instance where this becomes the interesting potential duty is creation of the peril. So I think you have a strong argument here that Julia created the peril that led to Katie dying, right? Julia is the one who checked out all of those books and placed all of the stacks in the hallway outside the room, okay? And so you could potentially argue again that Julia is criminally liable as a result of her omission for both failing to act and as a result of her legal duty to do so based on her creation of the risk. Now, I do want to mention this one more time. It's also important in your analysis to discuss whether or not Julia had information to know that Katie needed assistance and whether or not Julia was able to provide that assistance. So as applied to these facts, you know that Julia was aware, right? She opened the door and she saw Katie injured. And with regard to whether or not Julia had the capacity, you would have to make some assumptions. But if Julia is like stacking all these books and moving them around, that does suggest that she has the ability. It's not as if she has some sort of physical impairment that makes it impossible to physically assist Katie. Moreover, she herself doesn't even necessarily need to provide that physical assistance, right? She could just call 911. So again, Julia is criminally liable. There was both a failure to act and a legal duty in the form of creation of the risk. So this concludes our recorded presentation. Again, if you have questions about this, I know we covered a lot. If you have questions, please post them on the discussion board and we can re-review this information during our review session on Tuesday. Thank you and enjoy the rest of your weekend.